Well, hi, hello, and how are you doing out there in internet land? My name is Brian Trippett. I am the Front Porch Conservative, and welcome to another session of Chattin On The Porch, a fun little live stream that we do where we get together, we talk about the news, we give our views, and we try and make sense out of this crazy world in which we find ourselves. You can find us on Twitter, you can find us on Rumble, and you can also find us on that quaint little alternative social media platform known as YouTube. So if you haven't done it yet, tell your friends, send out the link, get everybody in here. We're going to have a very, very fun discussion this evening. We've got an old friend of the Electronic Front Porch who's come back, and we're always glad to have this gentleman, as his insight and wisdom in these matters is always appreciated, especially for what we're going to be talking about tonight. Again, my name is Brian Trippett. I am the Front Porch Conservative. You can sometimes find me under the moniker, the bow and the chapeau. You can sometimes find me under, all kinds of things. The common man with common sense. But in this moment, as always, I am your host. Again, we are on YouTube. We are on Rumble. We are on Twitter. We thank you for being here. We're glad to have you. Looks like everybody's settling into the house. Small Time Republic is here on the YouTube side. Glad to have you, brother. The Wingnuts are over there on Rumble. Glad to have them. WWG1, TBA, and all the rest of you crazy cats. Oh, my goodness. Oh, my goodness. Oh, my goodness. All right. Let's get right down to business because my guest is gracious enough to give me some time here, but I don't want to abuse the privilege, and I know he's got life to live and things to do. All right. Every time you get a piece of good news, Trump administration freezes spending of $29 billion at EPA. A judge about 3 days later is turning around going, you must spend that money. But Then we get some more good news. Trump deports criminal illegal aliens, but judge intervenes and says, injunction, you cannot do that. Due process. And it's all just maddening. My guest was asking me before the show tonight, what cases do you want me to focus on? Because there's like 130 of them. I said, I'll tell you what, I'll leave it to your good judgment to pick which ones you want, but we'll just kind of sound off on some broad themes. The gentleman that I'm going to bring back here is no stranger to the Electronic Front Porch, but if you're not familiar with him, you can find him on Blaze. He's been on Blaze Media. He's been on with the People's Pundit, Rich Barris. He's been on Sebastian Gorka Show, America First. He's been in all kinds of different places. He is the author of 4 different books, 3 of them, Fake News About Trump, Volumes 1, 2, and 3, and then also Fake News Exposed, his latest work. He's also on Substack. He's a practicing attorney. He is a number of things, and more importantly, he is friend to the Electronic Front Porch. Ladies and gentlemen, please welcome back one of the best, smartest people out there, Daniel R. Street. Counselor, how you doing this evening?
I'm doing good. I think I'm going to take that intro and claim it as my own and have everybody play it anytime I appear anywhere else. I really appreciate that.
No. I somewhat seriously, but somewhat jokingly tell all the folks that come on here, look, I am not rich and powerful. I don't have 1 million subs, but you will get the best intro I can possibly give you, on planet Earth and in this general solar system. God, it's been a long time since I've talked to you, brother. How you doing?
Doing good. I think the last time we got together was when the court held oral argument on the presidential immunity case.
That's right.
Was last year, not quite a year ago. I think last summer.
I think it was either April. It was either March or April. And for those of you who may not have seen it, we hosted a live stream. Daniel was here. I was here. My regular co-host, Ruben Christopher Haynes, Brentley from the Dangerous Rhetoric podcast. And we sat in and listened in on oral arguments on the presidential immunity case, which ultimately the court ruled in favor of Trump. But it's been a while, brother. So what have you been up to? What have you been up to these days?
I always tell everybody I'm working like a rented mule. So just a lot of work, a lot of litigation, a lot of office work, and then my writing and things that I do on the side. So I've been pretty busy. And of course, anybody trying to keep up with all the lawfare being waged against the Trump administration, that's a full-time job in and of itself. So that's why when I messaged you earlier, just to pick your brain about what you wanted to talk about, it's a target rich environment. So, the question is just really where do we want to focus? And but anyway, I'm glad to be back. I appreciate you having me on, and hopefully we'll have a lively conversation and inform some folks.
Well, I am hopeful that I tell you what. I mean, there's an old joke. It's like, and I think I heard former U.S. Senator Phil Gramm. He was debating something in the Senate, and he said, "Mr. President, I feel like a mosquito in a nudist colony. I don't quite know where to start first." And when it comes to this judicial, whatever the hell it is that's going on, that is about the truth. I don't know where to start because it's like, and there's so many aspects of this to come at, and my audience, much like yours, are probably some of the, best informed folks in and around the internet. And I'm not just saying that to blow smoke up their pant leg. I genuinely mean that. I mean, they throw stuff at me and I'm like, I didn't even know about that. But there's some things that I got to get my arms wrapped around, and I'm sure my audience would like to as well. And you've got to have a lawyer on, and this stuff goes right up your alley. So I want to dive right in because I know we've got a limited amount of time. Like I said in my intro, Trump administration does something, somebody takes them into court, and I'll just give you a fictitious jurisdiction. So Trump does something in the jurisdiction of Washington, D.C., in the District of Columbia, and then somewhere out in the District of Walla Walla, Washington, in front of Judge Acme. Yeah, it's a cheap Warner Brothers reference, but what are you going to do? Anyway, they go into this district court, and let's just take an example. I mean, because this is the things we talked about. Trump issues an order that Tren de Agua is to be deported from the country on the grounds that they are, they are an enemy combatant under Enemy Aliens Act, etc., and we're going to deport them. Somebody goes into the Walla Walla, Washington district out there and gets in front of Judge Acme, and the judge issues an injunction and says, nope, can't do that. Now, here's my first question.
Okay.
And again, this is lawyer. You're going to give me some legal lessons here. It's my understanding, and stop me where I'm wrong, but a district court, when it rules on something, can only rule on something, and the effect of the ruling pertains to the parties in front of the judge. In other words, all right, you're in my district. You have brought suit. We have two parties here. One claims to be injured. The other says there is no injury. I'm issuing a ruling. Am I wrong in my understanding of that?
No, that's the way it generally works. You've actually hit on the scenario that you described. You've hit on two of the very principal problems, two of the primary problems that we're having right now. One of them is the nationwide injunction issue, and I'll get to that. The second one is the temporary restraining orders or injunctive relief. So, first of all, what you described was an executive action. That's an action taken by the president under his executive authority through an order. So we usually call them executive orders. And the president, President Trump, has used executive orders extensively from day one of this second term of his. And what is out of the ordinary and unusual, okay, is parties, mostly leftists, are going to courts all over the country. Right now, I checked again earlier today, there are 210 pending actions against the federal government that meet these criteria in some form or fashion, attacking executive action. Now, in the past, let me get down into the weeds just for a minute to explain this to people. Ordinarily, if you want a court to review the action of the federal government, 99% of those actions are brought pursuant to the Administrative Procedure Act. The Administrative Procedure Act waives the government's sovereign immunity. Ordinarily, you can't sue the government unless the government says you can. Under the APA, you can sue the government over what is known as final agency action. So what usually happens is a statutory law is passed, an executive order signed, whatever, and a federal agency is tasked with doing X, Y, and Z. And they promulgate regulations. Those regulations come out. There's a procedure for all of that. It can be done on an expedited basis or an emergency basis. There's a procedure for that. Then the rules come out and somebody sues in court to stop them. All right, what is happening here is parties are going to court before there are any regulations and trying to restrain the executive branch right out the gate. And the reason that's usually not done is the United States Supreme Court ruled a number of years ago that the president is not an agency as that's defined under the APA. So the Administrative Procedure Act does not apply to the president, and it can't be used to attack the president. So ordinarily, it's not used to try to attack executive action. That has been radically changed under the second Trump administration. It happened in the first one also, but infinitely more this time.
Okay, so hang on. Let me make sure I understand something, because this is revelatory to me. So the president signs an executive action, let's just say, on whatever subject, and he tasks a particular department of the government to take care of that. That department makes rules about how it's to be taken care of. Am I to understand you to say that then and only then, after those rules are in place, can somebody bring suit? Is that?
Under the APA, there has to be final agency action as that is defined. Okay. So ordinarily you have to wait till there's final agency action. Now the agency can bypass the ordinary procedures with emergency rules and things like that and speed the whole process up. But here's another thing to keep in mind. The United States Supreme Court has ruled, this has been the law for 200 years, that federal courts cannot enjoin the president himself. Okay. So that's what makes all of this so out of the ordinary, extraordinary, improper, in my view, is the APA is not applicable to the president and CEO until an agency that's tasked with enforcing it passes the appropriate regulations. That's what usually happens.
Okay.
President signs an EO and an agency says, okay, we're going to do this, that, and the other. And then people are sitting there waiting. They're waiting for the reg to come out and then they go sue. Right? Okay. These people are suing, and they're suing the president, and they're trying to get federal courts to join the president and across the board. So all of this is from that perspective, from the rush to the courthouse as soon as the ink isn't even dry yet on the executive order, challenging the president under the APA is just totally wrong. There's a few circumstances in which that's not the case, but the vast majority of these efforts to obtain this expedited injunctive relief are improper for that reason, or for those two reasons. Now, the next issue that you raised is ordinarily when a party seeks injunctive relief. Now, let me back up and explain to everybody what injunctive relief is. An injunction is an order from a court that tells a person to either affirmatively do something or to not do something. All right, so bring a person here, that's an order to do something. Give someone access to a checking account, that's an order to do something. Okay. Give this person his job back, that's an order to do something. Those are injunctive issues. There are, for our purposes, there's three types of injunctions. There's temporary restraining orders, preliminary injunctions, and permanent injunctions. So I'm going to go backwards. Okay. Permanent injunctions after trial. And the court's heard all the evidence and grants a permanent injunction, and it's meant to be from now on. A preliminary injunction is once a case gets started and the court enters the preliminary injunction and tells the parties, you can't do X, Y, and Z until this case is resolved on trial in the merits. A temporary restraining order is issued by a court on very short duration. Under federal rules, the TRO, or a temporary restraining order, can only be for 14 days, and it can be extended for another 14 days. And the purpose behind the TRO is to maintain the status quo until the parties all get before the court. Okay, so I went backwards, but really you start with a TRO, and then you try to get it. If I'm asking for injunctive relief, I start with the TRO. I try to get a preliminary injunction. If I get that, then I try to win it at trial and make it permanent. Sure. Okay. So, ordinarily under the federal law, injunctive relief is supposed to be as narrow as possible. Okay. Right? Because it's an extraordinary remedy. It's the court interfering in the activities of people and telling them what they can and can't do. And here we're talking about the activities of a co-equal branch of the government. Okay. So it's the federal court telling an Article 3 power. So Article 3 of the Constitution grants the judicial power to the Supreme Court and such courts as Congress may create. And Article 2 power grants the executive authority to the President of the United States. So you've got two equal branches kind of fighting amongst themselves. So ordinarily, the relief on the injunctive relief that a district court can grant is the most narrow relief possible to the parties before the court. All right. That's the way it's done. That's the way it's supposed to be done. What has happened in recent years, and it's not just now, it's happened in the past, is for a court to come in and say, a district court, and it can be anywhere, it could be in Massachusetts, it could be in Texas, it could be wherever. And the district court says, hey, here's these 3 or 4 or 5, 6 parties. I'm going to seize this jurisdiction, and I'm going to order somebody, in this case, the federal government, don't do X, whatever that might be. But not just as to these parties. I'm going to make an order on behalf of all similarly situated plaintiffs and tell the government they can't do anything in the whole country for any of these plaintiffs, okay, or do anything adverse to any of these plaintiffs. So it's a nationwide injunction. So you get one judge who's wherever his district is, and he tells the whole federal government what they can do in the whole country. All right, now that's a nationwide injunction. That is a separate problem. It is a problem. It's a problem the United States Supreme Court is about to take up in a case that, there were 3 cases they consolidated that they're hearing in May. They're going to have an oral argument in May. They extended, the court's term's usually over. They're not usually.
Yeah, usually by June 30th. Yeah.
They're usually not going to decide any cases after all that. And so they've accepted this, and they're going to rule on it, presumably. And in those cases, those are the birthright citizenship executive order cases. They're going to have to decide. They might sidestep it. They can find a way to sidestep it, I'm sure. But they've indicated they're going to decide this issue about nationwide injunctions, because that's specifically what the government has asked the court to address. So,
okay.
And on that front, Congress is acting also. The House passed the Reining in Rogue Judges Act of 2025 with Congressman Issa from California. His bill, I wrote about that on my Substack. They passed it last week or the week before, and so the question is, what's the Senate going to do with it? Because that would end nationwide injunctions, as in fact, I think completely, except maybe there's some limited circumstances. I have to go back and read the statute, but none of the cases where the nationwide injunctions have been issued in the last 3 months would be applicable.
Okay. And I see questions on all sides from the Rumble chat and from the YouTube chat. I'm going to try and work them in the time that we've got. And one of them, and I think this is very applicable, TBA over on Rumble asks, so all the lower courts were created by Congress. How can a lower court seize a different district? Now, and let me broaden that out a little bit. Okay, so out in Walla Walla, Washington, Judge Acme issues an order that affects the entirety of the federal government and tells the Trump administration, or let's just take Trump out of it for a minute, okay? Mm-hmm. Let's just say any president, you cannot do this nationwide. Strictly speaking, and this, I know this is going to be more than a yes or no, but that's okay. Does a district court have the authority to impose a nationwide injunction? I mean, because if they're issuing this, I mean, it's one thing to just go rogue. It's another thing to say, hey, I got the authority to do this under X, Y, and Z. Yeah. So which is it? As of this moment, in some circumstances, federal courts do have the authority to issue nationwide injunctions. So okay. I know people think, oh, you shouldn't be able to do that. There's no prohibition on it because Congress hasn't prohibited it. And the Supreme Court has not prohibited it. So until the Supreme Court, and the Supreme Court's had several opportunities to rein this in, and there's several justices on the court who've written opinions, either concurring or dissenting or dealing with this issue. We need to stop this nationwide injunction business, but they haven't. So yes, the federal judge, in the appropriate circumstance anyway, can legitimately issue a nationwide injunction. Okay. Now, let me ask you another sort of a broad question. And I think one of the frustration that supporters of the president and again, to me, this goes beyond the question of Donald Trump. this is a good old fashioned, I'm going to use a word that's not appropriate, but it is, spat between the executive branch and the judiciary, which occasionally happens in the course of time in America. And I think a lot of people, and again, set me straight if I'm wrong about this, a lot of people are looking at what the judiciary is currently doing right now, be it at the district level, the appellate level, or whatever, and they're like, you're impinging upon the prerogatives of the executive branch in their ability to function day to day. I mean, and this was an example like, that I talked, we traded messages about on Twitter. Lee Zeldin, the director of the EPA, finds $29 billion and says, oh, we can impound this. We're not going to spend it, and we'll save the taxpayers money. Somebody goes into a courtroom and says, nope. You've got to spend that money, daggone it. It's been appropriated. That's your job. You got to spend it if the Congress says you have to. Well, that's an executive branch function, or at least I would perceive it that way. I think most people in my audience would perceive it that way. Am I wrong? I mean, are supporters of the president, or just anybody in general, wrong in saying, okay, the judiciary is way overstepping their line here? I mean, yeah, someone brought suit, and yeah, they've got to technically, adjudicate the suit, but this goes beyond adjudicating a suit. This is telling the executive branch what they can do. And again, with the understanding, it's the court's job to tell the executive branch, you are acting in an unconstitutional manner. This isn't even stuff that's questions of constitutionality. I mean, this is questions of, you can't spend money, you can't remove this person, you can't fire this person, you got to rehire this guy. I mean, are we all wrong in thinking this?
Yes and no.
Okay, fair enough.
Depends which topic you're talking about.
Okay.
All right. So first of all, a lot of this, what the Trump administration has been dealing with is illegitimate, and they're illegitimate actions. They're illegitimate, in my view, efforts by courts to further illegitimate actions, and that's why you see so many of the district courts getting reversed and having stays issued, because they're exceeding their authority. In many ways, it's what the Democrats planned, because in the Biden administration, I believe 235 judges were confirmed. Yep. And you had the Senate minority leader, Chuck Schumer, say, hey, we confirmed 235 judges, and they're throwing monkey wrenches into the Trump administration's wheels, and that's what we put them there to do. I forget exactly how he phrased it. Basically, They're doing what we put them there to do. And you see, I've written about a lot of these cases. A lot of them are brand new judges who've been on the bench for less than 2 years, and they were appointed or nominated by Joe Biden. And so you get a lot of these inexperienced judges who really, frankly, don't know what they're doing, and they're doing some things they shouldn't. On the other hand, there are some rules that are applicable here. So, for instance, the specific example you gave of the greenhouse reduction money, the $27 billion, that's is more than the EPA's budget, as a matter of fact, and Congress allocated it as part of the misnamed Inflation Reduction Act. And they created it's supposed to be the green banks. And you had these 7 or 8 NGOs that came in the last of the Biden administration, and they got approved for grants. And we're talking about billions and billions of dollars, $20 billion under 2 separate programs to either 7 or 8 NGOs. And the Biden administration set it up so the government, the Treasury Department, which usually doles the money out, it's not doling the money out. They gave it all to Citibank. And Citibank's the intermediary, and that's what the federal judges have been trying to use to get around the APA, okay, or the bar they have and the problems they're having. But anyway, that's another topic. But the point is that Congress has, under Article 1 of the Constitution, the power of the purse. And Congress has the ability to say, we're going to spend this much money, and we want this much money spent on X, Y, and Z. And the only thing the federal government can do, and the only thing the executive can do, is spend that money in accordance with the will of Congress. Okay, so there you've got 3 separate branches, co-equal branches, kind of smashing into each other. what the Trump administration said with respect to the Greenhouse Gas Reduction Act business,
okay,
which is the 20 billion ultimately that Lee Zeldin, the director of the EPA, came in and said, wait a minute, this was all done inappropriately. These NGOs aren't even experienced. Some of them were only created a few months before they're going to get access to these billions of dollars. They reported it all to the federal law enforcement and the United States Department of Justice, said we want all this investigated, and we're freezing all these money, we're canceling these grants. And what they told the courts is we're in the process of redoing all of this in accordance with the will of Congress. But whatever Congress ordered wasn't what was done by the Biden administration. So that's where they're at with the 27.
Okay.
The executive branch does not have the authority to impound funds that Congress has said must be spent on X, Y, and Z, except in very limited circumstances. So but on the other hand, if Congress funds something in its discretionary spending, then the executive can spend it within the broad parameters of that discretion. So what you wind up with is if Congress funds something for, improving education, improving, remedial writing for second graders, well, then the executive branch, the presidency and the Department of Education, whoever else that's authorized, has a lot of latitude on how they attack that problem with that money. Okay. And that's what President Trump's taking advantage of with respect to a lot of the discretionary spending, to say we're not going to spend it on diversity, equity, and inclusion, or DEI, or racially discriminatory programs because Congress didn't say we had to.
Right.
All right. Okay. So that's going to vary from one funding mechanism and one act and one law and one budget to the next.
Okay. Now, folks, now you begin to understand why I brought this good gentleman on to talk about all matters judicial and Donald Trump. And since we're at the top of the hour, let me do a real quick commercial for the both of us. My name is Brian Trippett. I'm the Front Porch Conservative. This is Chattin On The Porch. My special guest tonight is attorney and author Daniel R. Street. As a matter of fact, I am going to pop his website up, and I will put the links in both Rumble and YouTube. Folks, if you're looking for a good Substack to read, if you're looking for good books to peruse and try and figure out what the heck is going on out there, I highly recommend Daniel's work to you. He's on radio, he's on shows, he's all over the place, and God bless him for everything he's doing to try to illuminate understanding. And with that, let's dive into something else. And I've got a question from the audience, and this one's been bugging me. And probably it's like nails on a chalkboard to most people, whether you're a lawyer or not. From Small Time Republic, I think some of the illegals that are crying to have due process have already been adjudicated. All right, I got to ask you about this, because this, to me, is the craziest thing I have ever seen. And, these days, everything's crazy, and it's everything I've never seen. Kilmar Garcia. Okay. And it didn't even have to be Kilmar Garcia. Okay. It could be anybody else. The president declares that Tren de Agua and MS-13 are enemy combatants. They got to go. The president is generally recognized to have authority in matters dealing with immigration and national security. Okay. So you have people in the country who, and people acknowledge, and reporters acknowledge this, knowingly violated United States sovereign law to get in here. They have been here illegally for God only knows how long. Okay. President tries to take them out. And now, all of a sudden, the ACLU, who has been sleeping over the corner for about 30 or 40 years on questions of civil liberties, all of a sudden woke up and rediscovered the words due process. And the ACLU is not alone in this. I mean, you got due process. Okay, let's get into this for a second. If an individual or a group of them, like let's say a family, if they are indeed illegal aliens, they have knowingly entered the country in violation of sovereign federal law, how much due process are they actually allowed? And what should they or should they not be granted?
Okay. The answer to that is a little complicated, but let me tell you what happens. All right. As a practical matter, the due process that a person who's entered the country illegally is entitled to is very little. Okay. Very little. And the important thing to keep in mind is that due process, if you're a non-citizen, just honestly doesn't amount to a whole lot. All right. So when you start dealing with citizens, and to a lesser extent, people who are here legally, who have are permanent residents, things like that, their due process rights get somewhat greater than someone's here who's here illegally. But even then, it's not that great. You're here on a visitor's visa, you don't get much due process. And so, as a practical matter, not much. But here's what happens. Most illegals, and let's speak specifically with reference to Kilmar Garcia.
Okay.
Kilmar Garcia, just for all the viewers, is the fellow who was living. He's from El Salvador, and he entered the country in either 2011 and 2012 illegally, and he's been here illegally ever since. He was ordered to be removed from the country by an immigration court in 2019. Okay, but then they turned him loose after that. I'll explain that a little more. And then the Trump administration snatched him up and sent him to El Salvador. Okay, now what happens to these people is they get there are a lot of organizations that spend a lot of money to educate these people on the right things to say and the right things to do in order to maximize their rights. And so what this guy did, using Garcia as a for instance, he gets nabbed in 2019. He's been in the country for 7 years illegally by his own admission at that stage. And he's brought before an immigration court, and he makes an asylum claim. So he claims that, I came here because I'm being persecuted at my home country. And what I mean, look, I can't say that with specific reference to Garcia, because I don't know enough about who talked to him. But these NGOs, these non-governmental organizations, all these leftist groups go around, and they literally hand illegals these little pamphlets and tell them, here's the magic buzzwords you need to say to get more due process. Because he goes, I'm going to make an asylum claim, and he makes an asylum claim. Now they got to hear the asylum claim. Then he makes a claim under the Convention Against Torture. Then he makes a claim for withholding of removal. So, and he had lawyers, So these leftist organizations fund lawyers for these people, and you wind up having to go through this process and have hearing after hearing. In that guy's case, I think he had 3 hearings or 2 hearings and an appeal up until recent times.
Sure.
And so now if he had just been snatched up and didn't make any asylum claims, didn't make any claims under the Convention Against Torture, didn't make any claims for withholding of removal, what process would he have been entitled to? Very little. Right? Okay. But a lot of these people get kind of coached up to say the magic words. And they say the magic words to an immigration official, and now, okay, we got to put him over here. We got to have here. Hey, then is he entitled to be released while we figure out what we're going to do with him, and all that sort of thing. So it's a system that's being gamed by a lot of people. There's also plenty of legitimate claims that are made. There are war-torn parts of the world. There's oppressive governments trying to stomp people under their boot heel, and those people get here, and if they do it right and they make a timely asylum claim, and it's valid, and they have the evidence they need in order to prevail, they can be permitted to stay. All right. But what you have is this massive apparatus that's abused by, with frivolous, gross, just vast numbers of total BS asylum and Convention Against Torture and withholding removal claims.
Okay.
That's my opinion.
No, I don't blame you. And I mean, and this is something else that's got to be done. If not during Trump's term, somewhere in the near future, we have got to somehow put a rein on these NGOs.
And let me make another point, because that's the reason you see President Trump trying to using the Alien Enemies Act from 1798 and using these declarations, because he says, okay, now remember Garcia was an MS-13 gang member.
Right.
According to federal immigration judge who's an administrative judge. So, but that's not the same thing as TDA, right? So, President Trump declares that TDA is acting in concert with Venezuela, the Venezuelan government,
Right.
and as an agent of the state for a predatory incursion to undermine the national security of the United States under this proclamation. And he can use that to get these people out of the country expeditiously and skip and shortchange and stop any of that BS about asylum claims and any of that. That's why he wants to do it, because that way you can get the nastier people and round them up and get them out of here and not have courts tangled up for, a year or however long trying to decide what they're going to do with the people. That's why he's doing that.
Okay, fair enough. And we've got a question from the audience, and I'll pop this up here. And Zippy, thank you for the Rumble rant that goes along with this. Do you know of the Matt Hoover auto keycard case? I have heard. Okay, all right. Just wanted to ask. Now, I gotta ask you something. And Trump is I use this word advisedly, is notorious for using executive orders. And I can kind of understand why, because when you stop and think about the slow grind that is the Congress, even if you have a friendly Congress, and he's like, I want to get this done. I want to move. Let's get this done. I want to move on to my next thing. Is Trump bringing, and I'm playing devil's advocate when I ask this question, is Trump bringing some of this judicial pain on himself? Or is this just pure old-fashioned obstinance and we're going to slow him down no matter what? He's only got 4 years and we know it.
Well, I think some of it is what I would characterize as a novel use of executive authority.
Okay.
If you look at that Alien Enemies Act proclamation, and you go back to the Supreme Court, the United States Supreme Court decided a case in the third, I believe it was the third Roosevelt administration, Franklin Delano Roosevelt administration, after the war was over, about removing that German national. And that's where the court issued that decision. Say a lot of this is not subject to judicial review, even though the war's over. The president says that we're still in open hostilities. We can't review that, blah, blah, blah. Well, if you look at the process, if you go back and read that case, you see the process that German went through. There was an administrative procedure set up, and they had to run them through it. It wasn't something that was done, in a week. It was a period of months, and he had these hearings he had to have and all that. Well, Trump really condensed all that. He really condensed it, and you'll see that the courts don't like it. They're like, wait, this is happening too fast, because the Supreme Court did say in that case involving that German national in 1948 or 49, they said, look, there's no judicial review of whether there's a war or whether there's open hostilities or whether there's an invasion. But there is judicial review of whether you're 14 years or older and you're actually you're actually an enemy alien. So if there's going to be judicial review of those questions, so for instance, this fellow would have the right, or these people would have the right to say, hey, wait a minute, I'm not a member of a gang. And there should be a court that has the ability to hear that. That's according to the Supreme Court. And that's where you get in this pull, because the Trump administration is moving really quick, or they tried to move really quick with all that. Now, a lot of what the Trump administration did was not novel. So, for instance, a lot of these people that were shipped to Venezuela were people to El Salvador, were people who had already been determined to be removable. That's Garcia, for instance. Garcia was not removed under the enemy alien proclamation. He already had an order of removal and should have been removed in 2019 and wasn't.
Yeah.
So they're rounding those people up where they've already got removal orders under the Immigration Act, which is Title 8 of the U.S. Code, and sending those people out lickety-split. And that's great and needs to be done. But some of it's a little bit novel, and I think they were being novel on purpose. I wouldn't say that, I wouldn't blame them for it. I think they were trying to get creative to solve some problems. But it does lead to litigation, but that was going to happen no matter what route they took, in my view.
Okay. Okay. All right. Well, I want to get a couple of the comments in here before I get back to my questions. And Zippy was following up on that case he had mentioned with Matt Hoover. He said auto key card was a blank credit card size thing with an artistic print of an auto sear machine gun part on it. Matt promoted it. ATF could not make the part, but they still put him and others in prison for it. Okay. That's interesting.
Yeah, I haven't
Now,
read about that. I should have. I'm a big Second Amendment guy, a lifetime member of the National Rifle Association, but I haven't read about that.
okay. All right. Now I've got another question here from an audience member up in Connecticut. It says, do you think Bondi is slow walking or rather working behind the scenes? I'm a paralegal and I know how slow things can go. And this is a little off topic, but totally understandable. Okay, Bondi is a lot of different things, but whenever someone brings suit against the government, it's her Justice Department. Is weighing in on matters in front of the court. I mean, it is. What's your take on Bondi? Is she slow walking certain things? Is she working behind the scenes to make stuff happen? Like on Epstein, any number of things. What's your take on Bondi as an attorney general?
I think Pam Bondi's doing an absolutely remarkable job as Attorney General. And let me clue everybody in. Right now, the United States Department of Justice does not have all of the Trump loyal U.S. attorneys in place. There's 93, I believe there's 93 districts. There's 93 people that have to be confirmed by the United States Senate to man these offices. And then they have to get there and take the president's priorities, take the attorney general's priorities, and start implementing those, both with investigations, with prosecutions, with everything you can think of. All right. I didn't update the count, but the Democrats are doing everything they can to hinder the Trump administration from getting their U.S. attorneys in place and getting all of their other cabinet, all their other executive branch people that have to be confirmed. They're slow walking the confirmations as much as they can. Now, I think the majority leader is doing a heck of a job to push it as hard as he can, but there's just procedures in the U.S. Senate that you have to follow.
Yeah.
And so Pam Bondi's doing everything she's doing with a skeleton crew of the organization she will ultimately have in, like, say, a year from now. Okay?
Right.
And you're talking about an entrenched bureaucracy. You're talking about a lot of powerful, and I say powerful, people who've been in the office and held their positions for decades and things like that, who are going to undermine the administration at every turn. And she's got to root all those people out, strip them of their ability to hinder the government's programs and policies and implementation of policy, and then still defend all this litigation and everything else. I think it's utterly unreasonable. There are a lot of people who are like, Pam Bondi's not doing anything. That lady has one of the most challenging jobs in the federal government, and she's under a lot of pressure, and she's getting a lot of flack. And the people who support the president need to have her back, because she's doing a terrific job, and she's doing it with very shorthanded, in my view. And you'll see in some of this litigation that the lawyers they go in representing the government foul the government's case up. And some of that, it could just be because these things are moving so fast and coming so fast, but some of it's probably done on purpose, or at least with people who had, less than benign intentions. So I think I'd tell everybody, take a deep breath. And if there's anybody in the federal government right now you need to pat on the back, it's President Trump and Pam Bondi.
Okay, fair enough. Now, let me ask you something. You mentioned earlier that there's two ways to resolve this issue of judicial overreach at the district court level. One of them is, and to me, in the long run, this is the more appropriate measure. In other words, Congress is like, oh, no, you don't. We're going to prevent you from being able to issue a nationwide injunction, which is Darrell Issa's legislation that's recently passed out of the House. It's on its way over the Senate. What, John Thune as majority leader chooses to do with that's a whole other issue. But then there's the other thing, and this is something that not even judicial conservatives, but I think people who care about the court system in general are just absolutely scratching their heads over. Now, I've got some opinions as to the why, but a lot of people are making the argument, okay, well, this nonsense with these district court judges issuing their nationwide injunctions and other things that appellate court judges are doing, the Chief Justice of the Supreme Court, John Roberts, could bring this to a halt. He's just not lifting a finger to do it. Now, okay, there's a case that they're hearing in May that the court will decide before the end of the term. That's one way Roberts could deal with it, and not just Roberts, the entirety of the Supreme Court. Let me ask you a question, and I'm very curious to this. Laying aside, issuing a ruling from the bench with the entirety of the court backing him up, are there simple, practical things that Roberts has the authority to do as the Chief Justice with regard to these district courts that does not require hearing a case before SCOTUS? In other words, can he issue an order to, go back to my original example, District Judge Acme out there in the Walla Walla, Washington district, can he issue him an order and say, dude, judicially speaking, dude, you're not allowed to do this. You're not allowed to do this. This is a load of crap. Cut it out. Practically speaking, what power does Roberts have in and of himself in the role of Chief Justice?
Okay. There's, I get asked a lot of questions by prospective clients and people who come to see me about, can someone do X? Could the Chief Justice issue an order like that? I can't see why he couldn't. He could. I think it would be very improper for him to do that. And of course, he would always be subject to being overruled by the majority of the court. The court speaks in majorities, so that's why you'll get an application. The emergency applications are handled by the justices. The justices are on a rotation handling certain geographic areas, so they get an emergency application. They can unilaterally rule on that for a short time. So somebody gives an application for an emergency stay of something, and that's why you'll read in these orders, it was, presented to Justice X and by him or her referred to the court. Now that justice could say, I'm going to grant that and refer this to the court. And then the rest of the court would have to weigh in on it. But the Supreme Court is a court of original jurisdiction, and only a handful of things, and that's provided by the United States Constitution. And original jurisdiction cannot, Supreme Court's ruled, it cannot be made more broad, and it can't be narrowed. It's whatever the Constitution says there's original jurisdiction. And that's where you can file something in the Supreme Court. I'm filing in the Supreme Court. So that's original jurisdiction. In all other contexts, the United States Supreme Court exercises what is known as appellate jurisdiction. So there has to be a party that petitions the court in an appropriate manner, in this case, the United States Supreme Court, for some form of relief. The court's not supposed to say, hey, there's a case pending down in Oregon. We don't like the way that's being handled. And they just go and intervene in it. I'm not going to say they couldn't do that. Would it be constitutional for them to do that? If it's been done, I'm unaware of it. It's not. It wouldn't be proper. It's not the way the court functions. The court needs a litigant or a party in interest to present a request for relief, and then the court can act on that request.
Okay, but in that same vein, and I'm not, this is just me, thinking you mentioned something and it made me think of it. You said, the court doesn't have the right, to intervene per se, but recently, I think it was the Good Friday ruling on the illegal aliens being held, I think it was in Beaumont, Texas, that were about to be deported back. And all of a sudden, the Supreme Court goes in at the stroke of midnight after Good Friday, like the wee hours of Saturday morning, issues a 7-2 ruling. Go, no, hold up, no. So I mean,
that was on the application of the parties. The plaintiffs in that case, what the plaintiffs did in that case was grossly irregular, and the Supreme Court, in my view, for what it's worth, should not have entered the order you're describing. But the plaintiffs filed for an emergency stay, if you will, in the district court and an emergency appeal and a stay in the Court of Appeal and an emergency stay in the Supreme Court. The district court denied it. The Fifth Circuit denied it. And then ultimately, the Fifth Circuit dismissed the appeal for a lack of jurisdiction, and the Supreme Court granted it and said it stayed pending further order of the court and pending some other. I'd have to go pull it back up and see what they said. But there was a request for relief. Now, the point that Justice Alito made, it was grossly out of proper procedure for the Supreme Court to let that party leapfrog all those other courts in the manner in which it did. But the court didn't just do it on their own.
Okay. All right. Fair enough. So let's assume for a moment this case that the court is going to hear in May. Well, actually 2 days from now. Well, next month is May. 2 days is May. Probably around the middle of the month of May, they're going to hear this case on the birthright citizenship question and the question of, can a district court issue a ruling that just totally affects everything nationwide? And you said that, you had mentioned a moment ago, and again, I'm not trying to put words in your mouth, straighten me out if I'm wrong, that the court could take the issue head on because the Trump administration has asked them to do so, or they could sidestep this. Now, let's take that latter for a moment and just deal in a hypothetical here, because I'd like to get your take on this. It is becoming very worrisome, and not just for people on the right side of the political or judicial spectrum, but I think observers of the court, that the court can't put this off much longer. In other words, what I'm getting at is, sooner or later, if for nothing else, for the legitimacy of the judicial branch, the Supreme Court has got to make some kind of a ruling, not just on the question of district court's authority, but on any number of other procedural issues. Let's just assume for a moment that Roberts finds a very clever way, and I say Roberts somewhat disparagingly, I shouldn't, but he's been notorious for this over the years. Let's say that he and other members of the court find a way to sidestep this and they don't have to deal with it, or they choose not to deal with it. I guess I got a two-part question here. How much longer can they still employ that tactic and the legitimacy of the judicial branch not be severely, what's the word I'm looking for here? Not severely damaged? Because, the power of the court rests in its perceived legitimacy, in part. And if it's not perceived to be legitimate, in other words, you're being too cute by half, then why should we listen to you on much else? How much longer can they do it? And what happens if they don't start resolving these issues?
I would never underestimate the ability of the court, of any court, to tap dance around an issue. I've seen it time and time again in my career where a court, you think, okay, we finally got this case. This case is before the court. The court's going to have to tell us, and they find a way not to tell you anything, and then tell you it's judicial economy. That's judicial economy. We didn't have to address that. The court, judicial economy is the court supposed to address the fewest number of issues necessary to dispose of the case before it. And the reason for that is you don't want courts reaching out to gather issues that aren't squarely in front of them, because like the late great Oliver Wendell Holmes, Justice Oliver Wendell Holmes said, "Bad facts make bad law." So don't try to sweep everything in you possibly can. You're supposed to decide only what you have to. So how long can they do that? They can do it as long as they want. I'll give you, for instance, the United States Supreme Court could rule that birthright citizenship is constitutional, that's required by the 14th Amendment, and issue their own nationwide injunction. Because guess who does have the authority under every scenario to issue a valid nationwide injunction? The United States Supreme Court. And they would never have to, they wouldn't need to address whether a district court can do it or not, because they rubber stamped it and made it their own. And there'd be a way to sidestep it. The only way they would need to address the lower court's injunction is if they're going to undo it, right? So they can do that as long as they want. How long will it be before they have some deleterious impact on the perception of the court. I think look, there are a lot of people in this country who don't think the court is legitimate now. And most of them are lefties. But a lot of the people on the left don't think the court's legitimate because it's not packed with leftist stooges, So I'd hate for the conservatives to feel the same way. I don't have enough of my thumb on the pulse of the national electorate to tell you that for sure, except to say that I think anybody that's a court watcher, anybody that follows the Supreme Court and follows the court's rulings and follows the federal courts sees that the federal district courts are abusing their authority. And I think if the Supreme Court doesn't do something about it, not make it worse. Now they've acted time after time, and I've written 4 or 5 articles on my Substack about wins that the Trump administration has bagged over the last 3 months. And the Supreme Court's factored into several of those. So the Supreme Court has helped rein in the lower courts, but there's more they could do. And they need to quit. Like when some of these lower courts are activists and the Supreme Court will act in their rulings, they'll issue a ruling, they'll act like this lower court's legitimate and they're going to act like a normal judge. And that's not what happens. Right. So they need to get more aggressive and say, look, some of this BS needs to stop and the Supreme Court needs to be more aggressive about it. But I really couldn't tell you how much farther they could shirk their duty in that regard before we were at the point of no return. I would think it would be for quite a while yet.
Okay. All right. Got one last question from the audience. We'll bring this train into the station as I know we have a limited amount of time. Zippy over on Rumble and on YouTube, would not getting rid of standing force the courts to vet more cases so the facts can be boiled down? All right. For those in my audience who don't know, what is the doctrine of standing? And to his question, if getting rid of standing, would that force the court to actually really decide, we're going to vet this thing really good. We're going to run this thing through the ringer. So what are your thoughts on this?
Well, standing is one of the most complicated, little understood or misunderstood legal principles in federal law. Standing is really, in layman's terms, is just the requirement that a party before the court who's challenging some statute, challenging some action of another party, whatever, have enough skin in the game, so to speak, to actually have an injury for the court to address or to redress. So, and that's a constitutional requirement because the Constitution says that the federal courts have jurisdiction over cases and controversies. And that's where standing came from. And said, wait a minute, this guy doesn't have a dog in the fight. So this really isn't a controversy. You see, that's where standing came from. If the court did away with standing, I think really what your viewer's asking is if parties litigant were automatically given standing.
Okay.
Because there has to be standing. All right.
Okay.
Now the Congress can give parties standing. Congress can pass a statute and say any person can sue and enforce this. And that's statutory standing right there. All right. So Congress can handle it. So if Congress passed a law and says everybody that sues has standing automatically, would that would be a disaster. It would be a disaster. Yeah. Because then you get all these, look, a lot of standings used a lot of times to pare people down who shouldn't be in court. If somebody sues about snail darters and they don't have nothing to do with snail darters, the court says you don't have any standing. The state sues over something. You saw this in some of these cases. States sued, federal court said you don't have any standing. It's also used to frustrate the rights of parties to justice. So, for instance, Curling versus Raffensperger was a federal case been pending for 9 years down the federal district court over various different aspects of the election software systems and other things in the state of Georgia. Been tried on the merits over a year ago, and last month or earlier this month, the district judge dismisses the whole shooting match over standing after people have spent millions of dollars. Okay, so standing is both a shield and a sword. What I would like to see, and I think probably what your viewer was talking about, is in some circumstances, Congress could expand the standing that people have so that they can bring actions that have to be resolved.
Okay. Fair enough. Fair enough. Well, Daniel, it's going on 1 hour, and I want to thank you ever so much for carving out some time for us. This has been an absolute treat. Thank you so very much. Before we get out of here, where can people find you on social media? What can they do to support your work? Again, I'm going to go while you're doing that. I'm going to drop the link to your website in chat, but go ahead and give a plug for yourself, my friend. Where can people find you on social media, and what can they do?
Yeah, anybody that wants to follow me, the best thing to do is go to my website. That's danielrstreet.com. So danielrstreet.com. There are links to my Substack where I write about legal issues and fake news and media misinformation. There are links to my social media. I'm on Twitter at Daniel R. Street. I'm on True Social at Daniel R. Street. I've got books. I don't do as much media appearances as I used to. I'm just busy. I tell everybody I'm busy as a one-legged man at a butt kicking contest. I just don't have time for it. And I would also like to say, I appreciate you working with me through my technical difficulties. I've got thousands of dollars worth of high-end, camera and audio equipment that my IT people can't get to work. So you graciously allowed me to do this from my cell phone. So it was great to be here. It's I really do enjoy. I love the law and I love talking about the law. And one of my favorite things to do is to help demystify some of what's going on for folks who don't have law degrees.
Well, and we appreciate you coming on here because, like you said, I know you are busier than a one-legged man in a butt kicking contest, and believe me, I feel you. I feel you, my friend. But I mean, there's so much going on judicially, and it's just like I gotta talk to somebody, get my arms wrapped around this. So, I mean, brother, we're glad to have you here. As always, you have a standing invitation. If you got something burning on the brain you want to talk about, DM me on Twitter. You know where to find me, and I'll get you on here. So, hang on a second. Hang on a second. We'll say some proper goodbyes backstage. Folks, we're going to be back tomorrow night for the Wednesday night newsroom. Should be me. Going to check in with Tracy, see if she can show up. We'll be talking about some of the things going on in the news. Also, we've got another live stream this Thursday night. Kelly Lamb and Sean from Third Railify is going to come back on. We're going to do a post-mortem on the Canadian elections. Oy vey. Anyway, that's going to be fun. So hang loose for that. Keep your eyes open. In the meanwhile, folks, have a great night. Thank you for being here. Hit the like button on the way out. And with that, bye-bye.